Most people think that once those handcuffs click shut, your privacy is gone forever. But there is one piece of property you carry every single day, something you likely have in your pocket right now, that the United States Supreme Court has declared virtually untouchable, even if you are sitting in the back of a squad car. We have been conditioned to believe that police have total authority once they detain us, but the law actually draws several very sharp lines in the sand. Today, we are uncovering the 5 specific things police cannot legally do, even if they look you in the eye and tell you they can. By the end of this, you'll know the magic words that can stop a constitutionally illegal interaction in its tracks, and why your most private data has a higher level of protection than the clothes on your back. The first thing police cannot legally do is search your cell phone without a warrant, even if you have been placed under arrest. In the past, when police arrested someone, they could search anything on that person: wallets, cigarette packs, or purses. But in the landmark 2014 case Riley versus California, the Supreme Court recognized that smartphones are fundamentally different. Chief Justice John Roberts wrote that because digital data cannot be used as a weapon to harm an officer or help a suspect escape, there is no immediate emergency that justifies bypassing the Fourth Amendment. Think of your phone as a portable digital diary. It contains your bank records, your medical history, and your physical location for the last 5 years. The court ruled that because of the sheer volume and sensitivity of this data, digital privacy deserves robust safeguards. Even if an officer tells you they are just checking for evidence related to your arrest, they generally need a warrant signed by a judge unless there is an imminent threat to life or evidence is being remotely wiped. This leads us to a massive misconception about the power of the police at your front door. The second thing police cannot legally do is enter your residence without a warrant, your consent, or a very specific type of emergency. Your home is your most protected space under the Fourth Amendment, which guarantees your right to be secure against unreasonable searches and seizures. Many people feel forced to open the door just because an officer is knocking, but you are not legally required to engage or even speak to them. Silence and non-engagement are completely lawful. If they claim to have a warrant, you have the right to ask them to slide it under the door or hold it up to a window so you can read it before you open anything. However, there is a welfare check trap you need to know about. In early 2026, the Supreme Court confirmed that officers may enter a home without a warrant if they have an objectively reasonable basis for believing someone inside needs emergency medical assistance. This isn't just a hunch or a neighbor's vague worry. It must be based on concrete evidence, like seeing smoke or hearing screams. If you are fine, the simplest way to protect your privacy is to speak through the closed door, confirm you are okay, and end the interaction there. Outside of these specific emergencies, the castle doctrine stands. Without that warrant, they stay on the porch. Curiosity gap. What happens when an officer asks for a quick look through your car? This is where the third thing police cannot legally do comes into play. They cannot force you to consent to a search. This sounds obvious, but it's the most common way people accidentally give up their rights. Police are legally allowed to use intimidation, bluffs, and even lies to get you to agree. They might say, "If you have nothing to hide, you'll let me look," or imply that things will go easier if you cooperate. But once you grant consent, it becomes incredibly difficult to contest the search in court later. You have a constitutional right to say the magic words, "I do not consent to a search." If they search you anyway, Your lawyer can use your clear refusal to try and suppress any evidence they found under the exclusionary rule. This rule exists to deter law enforcement from violating your rights by making illegally obtained evidence inadmissible in court. The fourth thing police cannot legally do is command you to stop filming or photographing them in public spaces. As long as you are in an outdoor public area, like a sidewalk or a park, or on private property where you have permission to be, you have a right to record law enforcement officers. They cannot legally order you to put your phone away or delete your footage. In fact, if they want to view your photos or videos, they generally need a warrant to do that too. Recording encounters is often encouraged by civil rights groups because it promotes accountability and provides an objective record of what actually happened. Finally, the fifth thing police cannot legally do, and this is a nuanced one, is arrest you simply for remaining silent. You have a Fifth Amendment right against self-incrimination, which means you do not have to answer questions about where you are going, what you are doing, or your involvement in a crime. However, there is a catch you must understand: the stop and identify laws. In about 24 states, if you are being lawfully detained based on reasonable suspicion, you are required by state law to provide your name. In the case Hebel versus 6th Judicial District Court, the Supreme Court ruled that requiring a person to state their name during a valid stop does not violate the Fourth or Fifth Amendments. But, and this is the critical distinction, you generally do not have to provide a physical ID card or a driver's license unless you are driving, and you certainly do not have to tell a story or explain your presence. You can provide your name to satisfy the statute, and then immediately reassert your right to silence by saying, "I want to remain silent, and I want to talk to a lawyer." Understanding these 5 boundaries is the difference between being a victim of the system and being a protected citizen. The key lessons to remember are: your phone is a digital sanctuary that requires a warrant. Your front door is a legal barrier that you do not have to open without a warrant. Consent is a choice that you should never feel forced to make. Your camera is your witness in public spaces. And while you may have to give your name, you never have to give your silence. Common mistakes include trying to be too helpful by talking your way out of a situation or assuming that biometric locks like fingerprints or facial recognition will protect your phone as strongly as a passcode. When you know exactly what the law says, you have the upper hand in any interaction. Never forget that these rights exist to protect everyone, regardless of innocence or guilt, because a system that can bypass the rights of one person can eventually bypass the rights of us all.